Hello? Hello? Hello?
Hello, sir. You actually stopped when you explaining the elements of express or implied contracts. That was where you stopped, sir. Then there was network glitch before the lecture stopped, sir. Hello,
Okay,
sir.
1 minute. Just 1 minute.
Okay, okay, sir. Yeah, thank you. Yes. Sorry, was there attendant? Okay, for her. Okay, thanks.
I needed to just attend to something very urgent. So now, you were saying something that I stopped on my
Yeah,
slide.
yeah, yes, at
Can you see the
you
slide?
yes, you can see it, sir. You can see it. That indicates MBA lecture notes, business club. We can see it, sir.
Oh, okay. So,
I sent it to the
just send.
chat box. Where we stopped, I sent it to the chat box, sir. Yes, we've done all this, sir. We did this and that.
Okay, we done all these ones, I guess. We done acceptance.
Yes, very well, sir. We've covered that area completely.
So we covered elements of contract up to we stopped at offer. Offer was the last thing you were explaining.
do we discuss terms of contracts? Hello.
We
No,
were
sir.
discussing elements of contracts
Well,
where you
we're
mentioned
still
offer, acceptance. You were explaining offer before the network went out.
with acceptance now. So what? So we're just starting the class. So I don't understand. Did we do acceptance?
With acceptance, this is where we stop the
We
other
are
time.
just moving to acceptance.
Do we discuss anything like postal rule or acceptance by post?
No, sir.
Post okay.
No, sir.
Okay. But we discuss distinction between offer and invitation to treat.
No, sir.
No, sir.
So where we so we're doesn't mean we're just introducing the class or what? I don't know. So this is the beginning of a slide now. That means we didn't do anything on that day. I don't understand. Who is giving me information? So so that means we're starting everything afresh now. That's the meaning now. So let's start afresh than this. So you are saying that this is what I did that day. So we can no problem at all. Let's start afresh again. It's interesting. Can you hear me? Can the class hear me?
Yes, sir.
Yes,
I
sir.
can hear you, sir.
Yes, sir.
So what did I say was an offer? What's an offer? What did it say is an offer? Based on what the class that you learned at that time. Can someone answer my question? Can someone answer it? What's an offer?
So you said it's a promise statement made by one party.
No, it cannot be. That's not correct.
Okay.
So you
You did.
said it's a manifestation of an intention and is a proposition made by one party, the offerer, to another party, the offeree, indicating his willingness to be contractually bound on certain terms, provided those terms are accepted by that other party.
So I say that in offer because offer is a we try to say that because it's not just a statement, you know. Because the first answer that I was given, you just said that offer made to no, when you are saying you are going into a contract, an offer was made to somebody. So if you say made by somebody, made by a statement made by somebody, yes, to who? So if you make an offer and I keep to yourself, it cannot be an offer. It has to be somebody, and it has to be for a purpose. So if you are defending an offer and then you stop halfway, it means that that statement is incomplete. An agreement has to involve two persons. So if I'm making offer, it has to be somebody and about something and the consequence of that in law. And that's why we say that it's a proposition. It can be a statement, it can be a promise made by someone to another person, indicating the willingness to enter into a contract. You know, so provided that once that person accepts, then it's binding and it goes on and like that. So I believe in the last lectures, I also asked someone to we discuss the facts in Kali and Carbon company. Those facts were discussed in the class last week. Oh, we didn't discuss that one too. Did we discuss that facts in Kali
We
and
didn't discuss it. We
Carbon
didn't discuss.
company? Oh, we didn't discuss it. Hello? Serious. I said, did we discuss the facts in Kali and Carbolic Super Company?
So we have not discussed anything.
Oh, the case, even the case was not discussed in class. Is that what you mean?
Nothing, nothing.
Okay. So someone should go online and Google the case. Go online and Google the case of Kali and Carbolic Super Company. And just anybody should can just go on. That's how we'll do it. Anybody should go online, Google the case. Can you see the slide? Can you see the slide? There's
Yes,
a case.
yes,
Yes.
you can see the slides.
So you
Yes.
can see a case on the second paragraph. There's a case that Kali and Carbolic Smoke Company. Just copy it and search it on your search machine, either on your phone or laptop, because we're going to discuss it together. So we're saying that in offer, the issue is that intention. Anytime you want to go into an agreement with someone, it's something that you would have conceived in your mind. So if you want to, as you are a consultant, or you are a manufacturer, you do in particular services, or you have any business you are doing, there's no way that another person will just come to you and start that business with you. You would have conceived it. You would have conceived it, in mind. So what you conceive in mind must manifest. I can manifest either by way of in writing, the way you can do a note or send a message or make a call orally, or it can also be in writing. So when you're talking about an offer, we're saying that which you have in mind, it can be so we're just describing what you have in mind. It could be the purpose would be to supply goods and services. It could be to construction. It could be to clear some goods. It could be to, like University of Lagos, for instance, the university would have released advertisement for academic programs. You saw it, you apply for it, you attended, though something would have come up. So if University of Lagos is not admitting people, if University of Lagos is a person they want to admit, you see it in adverts, they would have manifested it out. Now, even if they want to, you have applied for interview and everything and want to admit it, the University of Lagos will also manifest it out in your admission letter. So, it's when you manifest something that you have in mind to someone and you intend to that should be a contract that it is known. So, if you are talking about an offer, as I said, what you're not describing it, the subject matter could be a supply of particular goods. It could be supply of services. It could be construction. It could be hire. It could be lease of warehouse. It could be clearance. It could be importation services. It could be what all of you are involved in terms of business. It could be admission into university. So that could be the subject matter. But someone would have expressed it out to someone else. So when you say disagreement, two parties must be involved. So an offer is that person who initiates that statement to someone, and the intention is going to a contract on certain terms. So every contract will have the central thing that you are going into. Every contract. Like University of Lagos, you and University of Lagos went into a contract. I'm not University of Lagos, but it's because University of Lagos has to perform its own terms that come in. So if I may ask, between you and University of Lagos, what is the subject matter of the contract? What's the subject matter of the contract?
The subject matter is admission, sir.
University of Lagos.
Admission.
What is the subject matter? Why are you in University of Lagos? Is it admission that you're in University of Lagos? What is the subject matter of the contract between the student here, you and University of Lagos? Is it admission?
That would be
Okay, so
to complete
an MBA program.
To complete an MBA program. Is it just completing MBA program? What exactly? Why are you here? You are here to get what? Tangible something. Certificate. That's all that you are here. That's if you can go to Shomuru and print a certificate, will you come to University of Lagos? If you can go to Bariga and print that certificate, will you come to University of Lagos? If I go to a Papa and print it out, will you come to University of Lagos? So the subject matter is certificate, not just certificate generally. MBA certificate. That is the subject matter of the contract. So, but you see that there's no way that there's no way that you and University of Lagos would have come back for that purpose unless someone would have expressed the desire to you. And so that's why you see that admission letter would have been offered to you in your own name. Even though you are in class here, I can see on the online you are about 68 or thereabout, something thereabout. The admission was given to you individually. Those offers were given to you individually. So there's no way, even if University of Lagos want to go into this contractual relationship with you, and they printed your admission letter and kept it with the university registrar, there's no way they would have known that you are given admission or you are offered an admission to accept or reject. So this applies to every contract. If you go to supermarket now, goods are displayed there. You go inside and pick those goods. Someone would have made. So if they have closed that supermarket, there's no way that you would have drove in there in the first instance to buy those items. If someone display a house for rent or warehouse for lease or office space for rent, or there's a call for advertisement for a job, if there's someone don't manifest something out, there's no way that you know that this is what this person intends, and also for you to respond by accepting and then creating that contractual relationship. So on daily basis, you go into contract. The clothes you were wearing, it was based on contract. It was voluntary. So if you go into an Igbo man, they don't want to sell those clothes to you. You can't force them that you must buy the clothes. The furniture you are using into your houses and offices is based on agreement. If they don't want to supply those furniture to you, they will say no, and you can't force them. The water you are drinking is based on agreement. The cars you are driving is based on agreement. Because if the owner did not want to sell, you can't force that person to sell them to you. So in all life, our life is built on contract, agreement, and it's voluntary. It's not imposed by law. So we're trying to now describe that scenario, and we're saying that because if you say that there's a contract with somebody, it means that if that person breached the contract, you sue that person to claim remedies against the person because of an enforceable contract. So now it's as simple as that. But then, what is contract? How do you detect? Because as businessmen, you go into agreement every day, but you might not know implication of one of those things. So you are supposed to become concerned with what you are going into. And so it's on that basis that we said that an offer, you can describe it in any way. That is a preposition, it's a promise, it's a statement made by one person. Because an agreement must involve two or more parties. It's made by one person to another person. I was saying the person that makes it no, it's known as the offeror. And the person to whom is made is known as the offering. And the offeror is not indicating the willingness to go into a contract, to bound by terms because the offer will come with terms. Okay, I want to supply me this goods. I want to supply me this car. These are the terms of payment. This is the color of the car. This is the year of the car. This is how I want it to be, tinted or whatever. So you would have described the terms, when to supply it, where the address that you're taking to, everything. You would have stated clearly, this is what you want. And this is what you do on daily basis. Even you send your children out, go and do this, you tell them, if you go out, go and do X, Y, Z. Those are the terms of that thing. If you are buying anything in your house, you tell the person supplying, look, what you are bringing should have this, that. These are terms of it. So those terms can be orally. If you go to a restaurant to eat, you would have requested that this is what and what you want to eat. Those become the terms on daily basis. So we're saying the person that makes an offer is the offer to whom that person the offer is made. It's not that the offer provided the other party accepts. It can be implied. Experience says that look, they can also be by conduct. If someone flow that you can turn into bread, you didn't without accepting orally or by writing. The fact that using implies that you know what is binding on you. So an offer can be made to one person, like you admit in class today as a group, only one person, group. Scholarship offers. There are some scholarships that are meant for people do masters MBA program. It means a group of persons. It could be to all Nigerian students. It could be to the general public. So there's no limit to which an offer can be made. And Kali and Kabolic Subo Company came in. In fact, it's a case that you cannot, he wants to say that you have done law of contract. You cannot avoid it. You must know it. Liaise with Oladipo to add you as a speaking, please. This class governor, is she here? Is the class captain with us?
Yes, I'm here, sir.
Yeah.
Yes, so let me hear from someone that Google that case, Scully and Kabul Small Company. Can you hear from anybody that have Googled the case? I read the case.
Yes, sir.
Okay. Go ahead.
So the Khalil and Carbolic Smoke Ball, it was said that the Carbolic Smoke Ball company produced a smoke ball that could cure an influenza and made an advertisement on the paper that whoever uses this smoke balls in a description with a prescription will not cut an influenza. So one Mrs. Elizabeth Khalil now bought the drug and used it according to the prescription and still said she caught an influenza. So now the court held in this case that no, the company said he didn't make an offer to Mrs. Khalil, but the court held that he had made an offer to the whole world at large, and Mrs. Khalil had accepted by buying the drug and buying the smoke ball and use it according to prescription. And so the court ordered that the company paid her £100 as stated in the advertisement.
Okay, thank you so much. Thank you so much. That's brilliant. So we see that the aspect that you also need to look at there. You know, the company did not only advertise, but they added there was some level of commitment that they put in that, but they said that to ensure that what was saying they were ready, they added that they deposited £1,000 with their bankers. There was a statement like that to that effect. That is very important because the question we're asking that, okay, now they want to determine offer. You know that in a transaction, there's always series of actions that are involved in one transaction, series of actions. So the question is, at what point can we say an offer is made? Or does it mean that every statement that's made in the course of negotiating a contract, every statement does amount to an offer? Because we're saying an offer is a definite proposition, a definite, this and that. So, but you know that in a contract or in a contractual relationship, even between husband and wife, before people become husband and wife, they will tell you that they would have discussed a lot of things before to reach the stage of husband and wife. So if this, we take it into a commercial trans, the same thing. There's no way that it just go to someone's office and you resume. No, would have been a lot of things from the background. So at what point can you say that an offer is made? Because at the point of an offer is the point of commencement of a contract. And so if you look at this case, it was issue of advertisements. So the question is, if someone advertised in an advertisement, generally speaking, is an advertisement for whatever thing you want to do, does that amount of an offer? That's the point that we're dragging at. So, so the quote itself, of course, if as we're going to see, they are not offers, but of course, this was an advertisement. So how then do you now say it's an offer? So the court had to look at other factors. Primarily was the fact that the company had said, you know what, we have deposited money with our bankers in that respect. So if you read that case, and also very fundamental, as Fatia said, the company, also argued that an offer that they say any member of the public that the name Kali was not mentioned in the offer. So it means that when you say that members of the public, that is vague and therefore not enforceable. But the court had to say no, you can make an offer to the whole public. But it's only that person who respond to that offer that contract is created and become binding on the parties, and that it's also a case of a unilateral contract, meaning that one person can also make um, you know an offer. So if you look at some of the elements of an offer also here, it must be definite, it must be certain, it must be unambiguous. When you say unequivocal, when you say that something is ambiguous, it means that it's subject to further questioning. So if someone make a promise to you, make a statement to you, and it's not clear, ask more questions before you get some clarification. That cannot be offered because an offer has to be definite. That is something in such that I should know what is your mind. Remember that an offer is a manifestation of what you have in mind. People are making notes from the background. Do we have the class governor here? Is she in the class?
Yes, I am, sir.
Can you? Okay, so reach out to the Olabiton to add you as a co-host so that you can mute people that are making noise from the background.
All right, sir.
So there are elements of it must be definite, it must be certain. You know, so if you make an offer or promise and it's not certain, then because and it's ambiguous, it becomes invitation to treat. So invitation to treat is as good as you are still at bargaining stage, that no concrete step have been taken to know that this is exactly what you have in mind, so that the other party will accept or reject. So you see elements of it. He must be willing to be committed. So the offeror who makes that promise first must be willing to be bound if it is accepted. And of course, the person that makes an offer must also have the capacity and must be communicated. So in other words, once an offer is made, you must communicate it. You shouldn't keep it in your mind. You know. So if any of these elements are missing, then it becomes invitation to treat. And so the meaning of invitation to treat, you are just inviting other parties to come, let's negotiate. That's the meaning of invitation to treat. You're just inviting someone, come, let's negotiate. You are not actually making any offer. So in the course of negotiation, that offer will be made in between, because this element of contract will not have a name tag for you to know. But then it's because at the point that the mind, what is the mind, has been manifested clearly, that the other party will know exactly what to have in mind. Because it's when you know what someone has in mind that you can accept to go in the agreement with that person or not. But when that which a person wants to go is not clear to you, very important. So don't just go into agreement because of sympathy, because of emotions. You must know, go into a contract based on exactly those clear things that you know. If you're not clear about the terms, you ask questions. Very important as businessmen and women. Don't just accept any agreement. Don't just, if you're not clear, ask questions. That's when it's only when you ask questions and you are clear about what we're going into that you can say, oh, the two minds have come together. An agreement has come into place. There's consensus at Eden. And then you proceed to perform that contract based on the terms as agreed. Right. So there's therefore a need to make a distinction between an offer and invitation to treat. As I said, an invitation to treat is just a preliminary stage in the contract, in the offer. It's a stage that that you pass through before you make an offer is established. So because as I said, a contract or offers involve series of actions or ways or communication as the case may be. Not all of them will amount to it. So, but then But then the question is that which all you must able to detect at the point that an offer is made, because that is when the contract will come to an end. I mean, the contract will be established, as the case may be. Oh, God. Right. So yes. So if I'm asked this question, now there are examples here. But let's go with the first. What do you call it? Goods are displayed in the shop. If you go out there, supermarket goods are displayed in the supermarket. You see them, in shops and things like that, pharmacy store and things like that. The question is that if goods are displayed in the market, building materials, pharmacy store, superstore, and all of those ones. If goods are displayed, who makes an offer? Is it the owner of the goods or the customer that's making the offer? And of course, you know that where you, for instance, you want to apply for a job. There's what advertisement in newspapers. You apply for those jobs. You went for interview and all of those ones. At what point in this transaction an offer is made? So if I may ask the class, when you see goods in the and you enter for to purchase, between the customer and the owner of the goods, who makes an offer? Yes, class.
The
The
customer, sir.
it is the no the seller. The seller makes an offer, and the customer will have to accept by paying for the offer to look at it whether he can accept it.
So, as a lawyer, what got you? No, so if we're saying that, go back and apply that against the element of an offer. We're saying the offer must be definite, Must be clear. So if I saying the seller is the one, or have in mind that what the seller is making as an offer to the buyer is clear from people. Yes.
Okay.
Yes, those are saying a seller. Why? Provide the justification now. Why is it? Why do
Okay.
you think
Yeah,
it's a
it
seller?
is the
Why?
seller because he has put his wares on display. That means he's definite. He has shown certainty that these wares or products are meant for sale before the buyer approaches. If he has not done that, the seller has not done that, the buyer won't approach him, approach the shop. So it is definite and it is certain that the seller wants to sell those goods for it to display it on the counter or the shelf. Yes, sir.
Settle.
Good afternoon, sir. I think it is an invitation to trade because since a contract must be definite, an offer must be definite. This one is just an invitation to trade that, oh, come, oh, this is what I sell. Oh. So if you're interested, when you buy it, that is when you now accept the offer. But that is just a mere invitation to trade, displaying an item on the shelf.
Yes, yes, yes.
Sir, good afternoon, sir.
Good afternoon. Yes.
An invitation to treat, I think it's an invitation to treat when you display goods on shelf because you're simply saying, come, like you're telling people to come and make an offer. So it's not a contract. What am I saying? These goods that are displayed on shelf is seen as an invitation to treat and it's not an offer. Thank you, sir.
So now, yeah, if you go back to Kali, people that will direct what is Kali and Kabul Small Company say about advertisement? Well, the issue of the law is I know in law when you say that something is like this, you would have gotten that source of the you answer from law, and law you can source of law are from cases that are decided, section the statute that is enacted, customs, tradition, international rules, and all of those ones. But the major ones are legislations and customs, legislations and case law. So when you say that this is what it is, it means that you should have an authority for what you are saying, so that you don't be as if you are just guessing. Because when you say law, it means law is as it is. So you cannot say in law exists unless if indeed that law exists. So when you say that, display of goods are not offers, it means there's a law that says so. If you say that they are offers, it means there's a law somewhere that says so. So I need to be, and this even in the exam when you are writing, giving answers in the exam, when you give an answer, you must give us the authority as to where do you get that source of authority from that you're making, because law is as it is, and it's presumed that everybody knows the law, right? So if I'm if just to guide you, what did Kali and Kabul Symbol Company say about advertisement? Or you can Google yourself. Is advertisement a contract? I mean, is advertisement an offer? You can just ask Google. Is advertisement an offer? So what did Kali from the Kali and Kabul Symbol Company? Who can just give us brief answer about what the um, what's there?
Good afternoon, sir.
Oh, okay, go on.
Yes, yes, yes.
According to Kali versus Catholic case, it's just a mere invitation to treat because according to them, they only make an offer generally to inviting the public to their to advertise their products. So they are not making any offer particularly to the to a particular person. But according to the definition of an offer should be definite. It shouldn't be because when you are making a mere to treat to the public like an advertisement, we are inviting everybody. We are making awareness to let everybody know that this is what I do according to Calipari and Kabuli case. So it was just a mere truth according to them because they were not making an offer to a person individually to an individual. They're only making a public and awareness to people. Thank you, sir.
Yeah. So if you look at someone should Google that case. The case is there's a case on the case of Pharmaceutical Society of Great Britain and Boots Cash Chemist. Can someone Google that? Um, someone Google that case. This help you to understand some of this things better. Can someone Google the case of or any of the cases that you have there? Any of those four cases, any of them, you can just Google any of them and let's share it together. Just like 1 minute, give 1 minute, Google any of those cases and let's share it together. Yes, 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 yes. Can someone read it out?
No, sir, you mean we should read the case study out?
No, yes, read the facts. What do you Google it and say it out? What do you get from it?
On my own view, in this case study, the pharmacy and the board is that displaying goods on on a shop sell and offer to sell. The court erred in favor of the defendant displaying goods on the like the decision of the case by the judgment is that displaying goods on a shop shelf is an invitation to treat, not an offer. The customer make the offer when they bring the goods to the cashier. They
Good.
were like, okay, there was I mean, that okay, yes, we were trying because the issue happened in 1933 between the board and the body of Pharmacy and Poison Act in 1993. That no, you can't just say, okay, if you are displaying a goods on a shop shelf, it's not an offer. The court now say no, displaying goods on a shop shelf is not an offer. Instead, the customer made the offer when they bought the goods to the counter. The pharmacy will then make the decision as to whether to sell. If they do authorize the sale, the cashier will accept the customer offer. That was therefore no breach of pharmacy and poisoning act. That's on my own view, sir. Dr. Prof.
Thank you so much. Who else can contribute this one part? And say Google any of them. So it's very important for you to know this thing, because if we're saying that display of goods is in the when you display goods, it amounts to it amounts to an offer. What I mean is that when the customer enters the shop, it's deemed that the customer has accepted the contract, and so he must buy everything that is in that something. Yes, Ugundele, Alex.
Yeah, thank you, sir. I checked out Fisher versus Bell.
Yes.
So the facts of the case are that a shopkeeper displayed a flick knife in his shop window with a price tag. So under the UK restriction of Offensive Weapons Act, it was illegal to offer for sale such weapons. The prosecution argued that displaying the knife in the window was an offer for sale, violating the act. So the question to be answered is whether displaying a product in a shop window with a price amounts to an offer for sale. The court decision was that displaying goods in a shop window is not an offer, but merely an invitation to treat. The actual offer comes from the customer when they approach the counter to buy. So Bell had not committed a legal offer under the statute.
Okay. So you see that if they are also contractual, they would have meant that. So the point I'm making here is that there are cases that have been decided in the past, and those cases now they are using it to demonstrate, to give you the position of law. So you see that in a contract that advertisement or display of goods in the shop and things like that, the person is still they still amount to invitation to treat. There are still preliminaries. There are still, when someone open a shop or supermarket or pharmacy and store goods there, in the eyes of law, those things are still preliminaries. They are not offers at all. An offer, every contract begins with an offer. That's why you have definite, and that's why you if someone display a shop, there's so many things in the shop. So how do you know in mind which item a customer goes in and is buying? There are some that the customer will go in and look for everything and say, no, I didn't see what I want. So, but it was definite. As the customer goes in, he would have actually gotten what he wanted. Or he would have bought everything in the shop. And that's because they are not offers. They're not offered because they're not definite. It's ambiguous. Because the customer will not even know which one. You don't even know which one the customer has in mind. But when the customer now pick an item, you see that it becomes certain, it becomes definite, it becomes clear that this is the item that the person have in mind that wants to buy. So at that moment, it's deemed that the customer is making an offer and it's not left for the owner of the shop to accept or reject. Contract for sale of shares. You would have subscribed to shares for the company. Now, if you pay, you will even pay because you have seen the prospectus calling for subscription. You pick the number of shares that you want and you pay to a bank. Who is making the offer? Is it you that's making the payment, or is the company that's making the offer by writing to you the number of they accepted your shares and all of those ones? So in all of those things, you need to know that there's a particular stage that offer is, and it's the beginning of the offer that is the beginning of contract. Where in action or a settlement don't amount to an offer, it's a primary stage, and then it's not binding on the parties because all contract must begin with an offer. All contracts begins with an offer, followed by acceptance and all of those ones, right? So that takes us to a second stage, acceptance.
Then you have maybe the next one, yeah, because it's a must.
You must. And I like
Acceptance. So
I don't like
acceptance.
when you start the broken one and the other
I
one that
want,
you
yeah,
can.
yes. I like be able
If
to
I don't
blend
like
with
that thing, then I'm not
yeah, you have not eaten a fang. I like it.
I like the instance of the share when you are cooking or crossing.
In that my area, it's not many there.
So I believe the class governor is not in this class.
And
People are telling about AFAM, they're eating AFAM, telling us what they're eating, where they are. And the class governor, are you still here? It's a
yes,
class
I'm here.
captain. So why do you allow them to make that kind of noise in the class? And the class is recorded. It's a recorded class. We're running live or even on the stream. People are telling me AFAM, are we eating this soup and all of those ones? And they're supposed to be students. This Dara see me or what they call it. I mean, come on. This is senior, this is master, so it's not on a graduate class that we're having here. Oh. And it's recorded. That means they're not attending, they don't log in to satisfy all righteousness. They're not even part of what we're doing here. It's not fair at all. Anyway, acceptance, as you said, is a final expression by the offeree. So remember that because an offer is made by the offeror to another person known as the offeree, the two of these must happen before a contract comes into existence. So an offer is a definite statement, and so acceptance also must be final expression of must final expression or agreement, or consent to the terms of that offer. you know so if it's not final or if it's subject to other things to be done, then that cannot be. Acceptance must qualify with the terms of an offer, and that's why there's a rule of mirror image rule. Just as when you dress up and you stand before a mirror, you see that it's the way you dress that you appear in the mirror. So it's the way an offer is that it should reflect exactly the way it is in a mirror. So when you are accepting any contract, it must be exactly the way it is. You don't start to go and modifying things. So there's what is called invalid type of acceptance, you know. And the major one is what is called a counter offer. A counter offer is when you modify a term of offer. That is, an offer is made to you, you accept it, but you now add something in it. You will feel that you have accepted that. That you feel that, oh, I agree, I accept this job, but they should they should increase my allowance to this. Oh, I accept the salary, but they should allow me for a 1 week break. Oh, I accept this, but they should give me weekly or monthly XYZ. Oh, I accept this offer, but then so you are introducing once you are introducing something that was not contained in the offer that's made to you. Note that what you are doing is a counter offer. What's a counter offer? Is that alteration, or is you're altering the terms of the offer? And the consequences of that is that the effect of that alteration is that it has destroyed the original offer. That offer that you want to accept or you are supposed to accept, that you're now altering it in your acceptance letter or words or conduct. By doing that, you have destroyed the original offer. So it's no more alive. You cannot even go back to it. If whatever you are altered or you are changed, and the other person say, no, I don't want to accept, I will not accept these changes. You cannot say, oh, you want to go back again. As some of you that know how to bargain, you want to price something. The person say, okay, bring 100,000. You say, no, I have 90,000. You say, no, I won't sell it. Okay, take 92,000. Okay, take this. Now you say, okay, I want to go back to 100,000 again. Know that once you are changing all those things, those prices, you are counter offer for counter offer. So one contract may have counter offer for counter offer for counter offer. So when you make a counter offer, also is that counter offer that, because that counter offer has already destroyed the original offer, it itself has become a new offer. So the person who was the offerer now becomes the offeree to accept or reject the counter offer. So take note that when you are negotiating a contract and an offer has been made, even with those of Lagos, if you look at your offer letters, if you say, oh, you write the university registrar and say that, oh, you know what, you want your school fees you pay by installment. When the installment is not in the offer letter, it means that you are altering it. It means that your acceptance does not correspond with the terms of the offer. And of course, you know that if university keep quiet, it means that your decision has been rejected. Just like that. So take note of some of those things that you are doing in the course of negotiation. There's also what they call, a contract that has this phrase in it, subject to contract. There are some contract offers that will have phrase subject to contract. You know, so when you have them, you can read the case of UB and Tejimola. Can someone do that? Someone should read the case of UB and Tejimola quick, so that we can look at it together. UB and Tejimola. Okay, the class is quiet. So, the effect of it is that once you have an offer that has the phrase subject to contract, it means that the the offer, the effect of the contract is suspended until that contract is made. So, you read the case of UBA and Tejimola. It was a case of when UBA wanted to hire Tejimola Property for that as a branch office, and they added in their acceptance that look, they don't take that. It has a phrase subject to contract, and of course, it added that they must carry on some specific renovations, changing some windows, some doors, and painting and everything. The Tejumula did that. When I borrow money, I even did all of those property, set it to the standard that UBA wanted. And just to be informed by UBA that they don't want to lease that property again. So Tejumula had to sue them for breach of contract. So, but when they are not examining the document, they saw that it contains a phrase subject to contract. And when you say subject to contract, it means that that document you have before you is not having any binding effect until that subsequent contract is entered into. So, for the fact that there was no contract entered into between UBA and Tejumula, the Tejumula was the case at P. So always pay attention as businessmen when they ask you to sign a document as a contractual document. Pay attention and watch the content of what you are signing. If it has a phrase like this, know that what you are signing before you has no legal effect. It's not binding until a subsequent contract is entered into. Very important. Don't just sign a document that they brought you to sign, no matter how hurry you are. Check through it. Now, there are also rules of acceptance, one of which is that silence does not constitute acceptance. Faith House and Bentley is there. You can read those cases. Of course, this was the case of someone that wants to buy a house. He want to buy a house from his own relation. Now, of course, and he added that, look, if I don't hear from you, I'll take it that you accept my request or my offer. The uncle wanted to sell to him what right, but he didn't communicate that out. He didn't manifest it. So the servant of the uncle sold the horse together with, auctioned the horse with the one that his relation expressed interest to buy. And of course, he now sued for conversion. So the question was whether silence amounts to acceptance. So, and the court said no, silence does not amount to acceptance, except in a situation whereby it will be construed as an acceptance. So if you read Afolabi's case, so can someone read the quotation that comes after Afolabi's case? Can someone read so that we know we're together? Can someone read that sentence that comes after Afolabi?
So it's is it that part? Study carefully and
Yes, yes, yes.
sign. Okay, it says, please read, study carefully, and sign the duplicate copy attached, signifying your agreement to all points as listed above, and return all your earliest convenience for records. So I return at your earliest convenience for record.
Yes.
That's
So
it.
you see this, yeah, you see this. So you can read the sentence that follow it. Go on.
Okay. There was no evidence that the plaintiff ever returned the signed document. It was heard that there was no acceptance.
Exactly. So you see that there are many times that someone, an offer has come to you, you are to accept, and the person says, okay, sign this thing carefully and send out a duplicate back, attach and all of those ones. You have intention of accepting it, but you just did that. You kept it on your drawer. You've forgotten. So it must communicate, because everything about consent, about what you have in mind, is two minds. Contract is about two minds coming together. So it must manifest by way of either in writing, orally, or by conduct. It must manifest. So when you have something in mind, you tend to accept, but you kept it inside the drawer. So there's no way that the overall would have come into your drawer to know inside the drawer whether you accept or not. So that's the point. Also, I want to take note you to take note of. You must manifest your acceptance. As just the way you must also manifest the offer. So if you look at the other rule again, acceptance by post. A post office. All of you would have known a post office where you write a document, you go and submit there. So two things will happen when you submit a document at the post office. Now the person who will have to receive it is your own work have finished. That is the staff of the post office that will ensure that that document reaches the addressee, the person to whom you are sending that document. Now, when it comes to offer and acceptance, and you accepted the offer by post office, so the question is you know, whether the contract comes into existence at the time you post or until the addressee actually receives the letter. So the rule in post acceptance by post is that the contract, because once there's offer and acceptance, that's the beginning of the contract. The contract comes into it, and other things follow. So for post office, once you send that post, at that moment of posting it, the acceptance comes into existence. So even if it takes 5 days, 7 days, 14 days before you receive it, note that it was 14 days ago that the contract comes into existence. So if you do anything in between, so assuming that it was submitted yesterday, you are yet to receive it, and then you sold that good to another person today, you have breached a contract because as of yesterday when the acceptance was posted, the contract had come into existence, even though you are yet to receive that letter from the post office agents. And that's what happened in case of Adams and Lindsay. Please Google that case online and read it. Google that case online, Adams and Lindsay. So that is the rule in Nigeria. That once you post an acceptance or when you post a letter or anything, that it takes effect at the time of posting, not at the time of receiving it. That's why if you don't want a post office to apply to your communication, you have to take it out at the time of negotiating. The same thing with respect to email. That when you now do the acceptance by email, does it mean that is it the time you click send on your laptop or on your device that it comes into existence or until the other person receives it? So all of those things are put into consideration. Now in Nigeria, there's no law with respect to whether email sent or this and that. But then sometimes they tend to construe the postal rule on as a requirement in the context of sending emails. So if you accept by email, if you can successfully establish by evidence, because the law is that if you allege, you prove. So if you allege that you submit the response by email, you prove that indeed you are submitting it by email. And so if it was also sent from your own end, you don't have control how emails move from one person to another. But what I mean is that if the other person have not received it at the other end, what will be the consequences? So these are things that you should take note of with respect to acceptance, in terms of acceptance in contract. Once contract is accepted, once offer and acceptance comes into existence, then the contract comes into place. So you also have the third element of contract known as consideration. So it's not about, oh, I will consider, I will consider, or I will consider. That's not what we're discussing here. Consideration here, you can call it a price for something. For anything you do, you must pay a price. You want to have MBA certificate, no problem, you must pay a price. That's the price you are paying. This price in different way. You have paid school fees. You also bought data to go in lectures online. If you are to come for lectures physically, you also buy fuel, or you will pay for taxi man that will come and drop you. You know, the time that you would have had for your family or for your work, you will not have that time again. You have to come here. You have to write exams. It means that in the night people are sleeping, you are up working. You have to. So you endure so many things. Even you have to buy new books because you want to do the same. Books that ordinarily you wouldn't buy, you are buying them because you need this. So many things. So why a layman will call it a price? Why a layman will call it a price? You know, the contract will call it consideration. A layman will call it a price. Contract will call it consideration. Something of value in the eye of law that you're giving in return. So, yes, the subject matter of contract, for example, between you and University of Lagos is the MBA certificate. But before you get that MBA certificate, the law will ask you, what do you pay in return? That's it. So, even University of Lagos taking school fees from you, they'll ask, why are you taking this post school fees? So at every point in time in contract, someone is paying a price. If you go into a supermarket and you are buying goods, the person is taking your money because they are giving those goods, and you're also taking those goods away because you pay money. So there's always a price for it. Your furniture is the same thing. Everything you are doing, there's a price for it. Even as someone would say, even in Freetown, South Africa, even in Freetown, there's no free food. You must pay a price. So a consideration is, of course, you can call it the price which one party pays for the promise or act of another. So it consists of rights, interest, profit, benefits according to one party, or forbearance, detriment, or so that it can be, you may undergo some suffering to get some benefits. Like what we're doing now, you're undergoing some suffering to get some benefits. You know, it could be profit, it can be so. For the bottom line is that which, of course, which you are paying for it was something of value in the eyes of law. That's the thing that you can see there. And the most important thing that you should note here is about the fact that consideration need not be adequate, but must be sufficient. So when you're talking about something that is adequate, it means that, like if you're selling your phone now, the question is, what is the market value of the phone? If you're selling your house, what is the actual market value of the house? So that means that if someone is buying that house from you, it must pay you exactly the market value. A phone exactly the market value. Now, but that's not the law is not bothered about that exact market value. The law is bothered about whether what you pay is sufficient for the person who is receiving that payment. So if the value of the house is 100 million and you sold for 10,000, as long as there was no coercion, it was voluntarily, no mistake, no fraudulent arrangement. If you willingly, that's sufficient. The law is not bothered about the fact that, oh, you are selling a house, you are taking 10,000 for a house that is worth 100 million. Are we together in this class?
Yes, sir.
Okay.
Yes, sir.
So the law is
Yes,
not
sir.
bothered about, yes. So the law is not bothered about adequacy of it. The question is it sufficient? Is that what parties bargain for? Is that sufficient? So that's what the law is talking about. But just that it must not be illegal. So you cannot, if consideration should not be for something that is illegal or contrary to public policy. Like you are saying you pay a price because you participated in the armed robbery. There's a case that we're going to see about illegality too. Everest and Williams, that those criminals they agreed that they will rob bank and share the proceeds of the robbery. They did that successful. And one of them claimed that he wasn't giving his own share as agreed. And he went to court to sue for breach of contract. And the question was, what's the consideration that participated in that crime? You know, but what he did was illegal, was against public policy. So there's no way that would have been a valid consideration. Of course, as we'll read the case, I don't know if I judge in that kind of case. What do you do? I'm asking the class. What do you do?
So you'll be arrested too. Or arrested too.
You arrest the man.
So it's like part of them, part of the offenders or those that went for the
Oh. So the lawyer. Wow.
This guy go watch him now.
This Okeranti, are you talking? Is it the answer you're giving? Who will watch this one when you talk? Is it the answer to our question? Or you something else? All are there for you. Please remind yourself that you are online, before you start exposing yourselves. Be conscious that you're online. So, piece of cancer. That's what happened in that case. So, in fact, they don't even arrest them. They don't even arrest the one that went to court. They invited that one to also come and testify, and all of them were arrested and executed. They killed all of them. Imagine you go and rob UBA, University of Lagos branch, and then you are here telling someone that you don't get to share your own this thing. So they should give you this and that. Yeah, so um, it must be illegal and all of those ones. So then there's something that I also have to talk about with respect to what they call promissory estoppel. Now, this also flow from the issue of sufficiency of consideration. It must be sufficient and things like that. So when you say that it's sufficient, it must be sufficient. The question is whether when it says that it's sufficient, um, as I said, it need not be adequate, but it has to be sufficient. Now, promissory estoppel as applicable to businessmen and women is someone is owing you amount of money. There's a schedule of repayment and all of those ones. Now, you are in need of cash, so you ask that person to pay you part of that. We are supposed to pay you, maybe subsequently supposed to pay you maybe in 2 months time or 1 month time, but then you will agree that they should pay you part of that amount early. Now they should pay you that part of that amount early. Now, after the person has paid you part of the amount early and you collected the money and do everything, then of course, you know. So the question is that can you still go back and collect the balance? Can you still go back and collect the balance? That's the point I'm making here. Right. So the question is whether payment of lesser sum will discharge the obligation. So generally speaking, in the as a general rule, because in law, when you say general rule, it means that there are also exceptions. So the general rule is that if you pay lesser amount for that or the total sum, the person can still come back and claim the balance. But then there are exceptions. There are exceptions whereby the law will stop you from claiming the balance, and that is why the issue of promissory estoppel comes in. So there are exceptions listed there. If you can read them out, the following are exceptions to the general rule, which I was. Someone should read those exceptions out so that we'll be together. Yes.
The following exemptions exist: introduction of a new term, promissory estoppel, composition when there is accord and satisfaction.
Yeah, those are the exceptions. Exceptions to the rule that the party can go back and claim the balance of the debt. So, but then where there's a new term, where you introduce a new term to that something, other than the person supposed to pay the full balance, but you introduce something, okay, give me half all the following terms. The person has gone to even suffer it and pay it because of those new term you have. You can't go back again. Or promise, promissory is from promise. Estoppel is from stop. So you made a promise that I will give you half of it. You won't actually, and you forget the balance. I'll give you that half. That the law will not stop you. The law will not stop you from going back to your promise. That's the meaning of promissory estoppel. Estoppel is when you stop someone from going back to his statement or his promise. You know, I can Central London properties. It was about rent, a rent that, you know, someone took the property at the time that property was not there. Say, don't worry, just take it. I will subsidize for you. You have taken that, and then you change your mind in between. What some landlord will do, you can always please promissory estoppel. Composition. Someone has into a debt with you, and there's already agreed terms of repayment, but you now came back and restructure those terms of payment. You can't go back to it, or when there's a code and satisfaction, or other services or something else has been done to you, and you are satisfied. You can't go back to claim the balance of that debt, as the case may be. So take note of that. When someone is owing you, and you are saying, oh, just give me half of it, I will forget about it because I need money now. Even if you say, I need money now, know the consequence of what you are going into as businessmen and women. So the other element of contract is intention to create legal relations. Intention to create legal relations. Now here, what is important here for you to notice that in contracts, as I said, contract is all about manifestation of intention. So, but there's no way that as a human being you know what goes on in that person's mind, except you are God. So, unless that is it. So, how do you now determine? You can only presume. So, in law, you can only presume someone's intention. So, to presume that someone's intention, agreement are divided into two. You have social and domestic agreement, you have commercial agreements, and you have intermediate agreement. So based on that, the law now presumes. So in respect to social and domestic agreement, the presumption is that parties do not intend to go into legal relationship. They do not intend to bound by agreement. So what are social agreement? Between classmates, with respect to attending weddings, attending birthday parties, social gathering, and all of those ones. Husband and wife, children, and all of those ones. Husband promising the wife, not in a business setting, as husband and wife relationship, promising the wife, I'll buy you a car at your birthday, and then at the end of the day, the husband is complaining about Tinubu government and all of those ones. Ideally, can the wife sue the husband for breach of promise to buy a car? Yes, I'm asking the madam to the house. Can the wife sue the husband for breach of promise? The wife, your husband promise you that you buy you a car or you buy you a new house, take you for holiday to London, buy you this goat, buy you this and that. Now he did not do it. Can you sue your husband? Yes, yes, yes. Dara Simi, yes.
Good afternoon, sir. I do think, yes, if you want to sue, if the person wants to sue or the wife wants to go ahead to sue. So in a case where maybe it's an estranged marriage and you once promised your wife in the marriage that you're going to buy her a car or a house or the house she's living with in, then she's going to own a certain property. If you guys are now estranged, I think you can sue for that to collect all of that back or make sure that all your promises, maybe you fulfill it. So I also want to ask a question, but that's my thought, that's my own question.
So as a follow-up, for instance, so when you now promise your children that go to school, I'll send money for you and not send, can your children also sue you? Because they promised to. Can the children sue their parents? If you do well in school, I will dig you XYZ. Now the children have done well. They pay a price by doing well. Now you don't give them the money. Can they sue you? Yes, I'm asking the class.
No, sir.
Yes, go on there. Oh, why? I don't understand. So, but you're saying wife can sue the husband, but the children cannot sue you. See I can now understand how husband are suffering.
The parents.
Uh,
The children have the
you
right
say
to sue the parents.
to sue the parent for
The
not
children
giving them
also
money.
have the right to sue the parents as well.
They can sue
Yes.
okay, for not giving them money in school.
Yeah, if the wife how what it take to sue the husband for maybe you promise something and you did that for free, the children also have the right as well to sue the parents.
But they're underage now.
No, what is my underage? 18 years. Let's say that 18 years. So someone that cannot sue, they can sue now.
For someone that is a child that is underage, they are not yet of age to go into a contract.
No, they
So
sue.
going
They cannot sue. There's what they call juvenile code now. You don't know about juvenile code. There's a code for people that are underage.
so what I'm saying is that
The
is it
same
possible
code
for
that
someone
when
that
they're
is underage to
sitting,
get into a contract? Will it make
they
the
can
contract
sue.
valid?
Yes, their contract are binding on the people that are underage. Yeah, of course. Well, that's one capacity. All contract
Okay.
are necessary. Yeah, there's some contract that are binding on contracts of necessities that are necessary in their life. They're binding.
But
Yeah.
there's no
But sir,
excuse though.
is there any law that backs the claim that the children has what it takes to sue the parents in such
That's what
situation?
I'm
Because I
asking
have
you now. That's what I'm asking you. That's what I'm asking you. You know, a contract is between parents and children, and it's not in the commercial setting. You promise your children that look, oh, this is what you could do every day. Go to school, do way my son, my daughter. I will do this to you. You knew deep down that you are just trying to encourage your daughter. Now the daughter have avoided all friends. You couldn't do anything social in life because you want to fulfill the father's destiny. Now you have done that. You are saying no. You are complaining about Tinubu administration, how this government. You are never seen this kind of bad government like this before. Now they want to sue you. You are saying, don't you know I'm your son, I'm your daughter? I'm sorry, don't you know I'm your father? Don't you know I'm your mother? That's what we're saying. It's contract.
yes. Uh,
It's contract now.
hello,
My lord,
sir.
if I may.
Yes.
It's like some
The
parents are worried now. Some parents
hello,
are worried now. Yes, go on.
yes, sir. The son or the child can actually sue the parent if he has the proof to show that the parent actually sent him there to school without fulfilling his obligation. So it can actually be
Now,
sued.
so the issue is this. So you look at this very well. From the eyes of law, whatever all the agreements, offer and acceptance, all of those ones taking place between parents, husband and wife, children, and all of those at the domestic level, at that level of family relationship, in the eyes of law, the presumption is not to create any binding legal relationship. So if husband is promising wife, in the eyes of law, they're not doing love, nothing more than that. Now love, they shack them. So as but if they're in a strange relationship where they're separated, like what the other counsel said, if they're separated, that one they're not in that relationship again. I know you are busy promising her, come back to my house, I'll do X, Y, Z for you. Know that at that time you're making that statement, she's no more with you as husband and wife. So at that case, she can be binding. That's the way can be binding. So when you send your wife away, send your husband away, and then you are not saying, my husband come back, I will do this for you, do this for you. Like what happened in Bafo and is it married and married? That even when the man was promising the wife that had run away before, they separated before, now they want to come back. The man was promising, I'll do this for you, do this. The woman asked, remove paper from the car and gave the man, well, write down what we're saying here. The man wrote down. When he came back, became one, the man started the same thing again. He said, he want to send her away. He said, no, that would be a breach of contract. And you must give me this house, give me this house, give me this house. And because the man wanted to prove that, oh, his husband and wife, there was no intention to create a relationship. The court not listen to him because at the time they were making that statement, they were no more in that relationship with husband and wife. But the point we are making is that, look, know that once you are in that relationship with husband and wife, and you are making promises, my wife, I will take you to France, I will take you to this one, just take it there in the house of law. The man is just playing love. Sorry, you don't apply law at home. If you take law to home, you can't walk. So just have it that this is what the law is. Don't start looking at your husband or your wife as someone that the law is saying you are just playing law to me. Mm-mm. That one, those law doesn't. If you bring law into house, it cannot work. Put law outside though. Family and law are not different thing. Don't come to the house and say you start playing that you sabi law, sabi law. It can't work. Demola is it? Demola, yes.
Okay, thank you for that, sir. So while I'll agree that that kind of promise is domestic or social arrangements, right? But what if in a case where maybe one of the spouses maybe gave up something like a job, right? In this case, the consideration for the promise. Can the law accept it? Is it legal?
Give you job on
And they
what
can
condition?
show proof for it, right? So
Give
for
you job for what?
instance,
Give job for what? I don't understand. Give job for
so
what?
for instance, the husband promises that okay, I'm going to build you a house. There's a need for relocation. So the wife works with a bank, and because of that, she has to give up that job. So and when they relocated, there was nothing in the wife's name and all of that. So can the wife, file a suit in that case? Will it be admitted?
Once it is in the context of you know, you know, once in the context of social agreement, once in that domestic arrangement, the law will just presume that you guys, because there are many rules that come into play there. And of course, sometimes it depends on the mind of the judge. But just notice that look, oh, all these promises made between husband and wife, the law is still not looking at the two of them, but there's no intention to create legal relationship. That's general. That's the presumption. So the issue that I say because it's a presumption, if you bring and not just presumption, it's a rebuttable. There are two types of presumption. There's what they call irrebuttable presumption and rebuttable presumption. So the type that we're discussing is rebuttable. That is, if you have strong evidence to show that, oh, yes, we're husband and wife, but this was not, you must prove it. If you're able to prove successful, why not? Because it is rebuttable. So but you must prove that indeed how this is the case. If you are able to show, the burden is on you because the law is presuming that there's no intention to create the relationship. You are saying that there was intention, so you have to go ahead and prove it. If you can't prove it, nothing for you. Demola, that is it for that one. So
Yes, I think that answers it. If it's you can prove it, so the court can
okay,
admit it, right?
yeah. So you have the
Okay.
evidence. Why not? But if you can't prove before the court, the presumption will still stand. So because the same thing in commercial transaction too. In commercial transaction, the law presumes that parties intend to create legal relationship, but it's also rebuttable. You can bring evidence contrary. So between husband and wife, if the wife has a superstore, has a shop, and the husband has gone there to pick item, the law would presume that he wants to. There's a binding legal relationship because that's the commercial setting. That's commercial setting. So, but it's also rebuttable. Not every commercial agreement has the law intent that should be binding. you know so you know like betting agreement, all this betting agreement, bet Niger, all of those ones. When you are betting, there's a clause in that betting agreement that says this agreement is in honor only. When you see agreement that has that phrase either at the title or in the middle or somewhere that has this agreement is in honor only, that telling that is an honorably agreement that is tend to be just like gentleman agreement. There's no intention to create legal relationship. That's why even in betting, if you bet and you won 100 million, they will say they don't have 100 million, they have only 20,000. You take them to court, they will bring the agreement and show you. Just that not everybody that some people that bet don't even know that such agreement exists, but they do. Those things are there before they are almost in all pulling and betting companies. That's what you sign before you start betting with them. So you can't sue them if they this will pay you less than what you want. you know Collective agreement in working environment, parties in the collective agreement, there's no intention to create a binding legal relationship in that regard. you know or so when union have enter into agreement with the employers, it's not binding on the employees until extra steps are taken to integrate that collective agreement into working condition of terms and working condition of that industry or that company or that employment, as the case may be. So collective agreement per se is not binding on anybody, until it's introduced, integrated into it. So even if you watch at the time that federal government agree with unions on the on the wage increase, salary increase, they have to go and enact a new law that say, okay, this is the minimum wage in Nigeria. If you don't enact that law, that collective agreement they had per se wouldn't have been of any legal effect. These are things that you need to know with respect to intention to create legal relationship. They are all presumptions. For domestic and social agreement, the law presumes that there's no intention. But if you have strong evidence to show that, oh, there was intention, fine. He who alleges you prove, the court to look at it. For commercial agreement, the law presumes that there's intention. But if you have evidence like pool companies or betting companies, the agreement was in honor. So you see that even though it is a commercial agreement, the intention is not to create any binding legal relationship. So it's flexible, those ways, as the case may be. So the other element is capacity. This is the last element, capacity. So the general rule is that every person have capacity to enter into a valid contract, but there are exceptions. There are some persons that the law take it out there to protect because they are vulnerable. They can't reason out the way an adult will reason, right? So capacity, as I said, general general, everybody have capacity, but then there's some person that law to protect. One of them is illiterates. So illiterate is someone that cannot read and write the language of the law, of the contracts. So if the contract is English language and you cannot read and write in English language, you become an illiterate. If the language is in Yoruba language and you cannot read and write in Yoruba language, you are an illiterate, even though you're a professor of English. So the law requires that the language of the contract is important. So if you you don't know the language of contracts, then you become an illiterate. And once you're an illiterate, there's a requirement that that agreement must be made before it's binding on the illiterate. And that you can find in Lagos State. You have section of illiterate protection law of Lagos State, which provide the requirements. Can someone read those requirements? They are self-explanatory. Can someone read out those requirements?
So if you read out what?
The requirements for illiterate that must be before a contract is binding on an illiterate. Is there on the slide?
Write his name and address on the document. Ensure that prior to the document being signed, it was read over, explained in the language understood by the illiterate person, and state that he was instructed to write the letter or document, and that the letter and document fully and correctly represents his instruction.
Yeah, so it's self-explanatory. That is the person that is writing that document on behalf of illiterate must write his name and address. Ensure that before the illiterate sign, read over and explain to the illiterate. Of course, states that it was instructed to write on behalf. So that must be contained maybe at the cover page or somewhere in that agreement before it's binding. If you don't do that, just forget about it. The contract is not binding on the illiterate, right? So also Ocean State has its own different there, has the issue of it must be executed parties must do that in the presence of the magistrate or area codes grade A or B, customary code area A or B, I guess maybe. Then for infants for under the Child Right Act, someone that is less than 18 years. So it means that somebody that not is less than 18 years on the Child Right Act cannot go into a valid contract. So how can then an infant create a binding contract? So as a general rule, it's not binding, but then for the purpose of contracts of involving infants, contracts are divided into several parts. Contracts for necessaries. Necessaries are things that are important in the life of infants, and such contracts are binding. Contracts that are not necessary, necessaries are things that, as an infant, it varies. If you have a rich family, things that you need as a rich person are different. If from a poor home, or an average home, your needs are also different. you know. So this is all very, but then whatever can help a child grow up to be, such things are binding on the child if the contract was in that direction. So contract for beneficial contract or service, depend on the circumstance of each case. So like tutorial, there are some parents that will hire someone to come and do tutorials for their children. Such person, if you don't pay the person, you can always sue the child. But if the child already have a home tutor, you can't go on the back and create another layer of that and say you are also teaching that person extra when in fact the parents are already engaged in the extra teacher to that for that child and things like that. So contract beneficial of beneficial service to the child and contract on necessaries are binding on the infants, whereas other ones are not binding. Contracts for loan, giving a child a loan for what it doesn't need, you can't get this loan back. You know, I owe you for what? You know, so but things that are necessary without which a child cannot really exist. Those ones are binding. So you take note of those things that are binding on the infant. Then the last one is contracts involving company, the capacity of a company. Now for company, the capacity to go into a contract for regarding company is you can find it in the object clause, of the company. Um, so every company has at the corporation you look at the memorandum and download memorandum. You can check it there. You see what they call the object clause. The object clause is where the company states what it's going to do. You state the purpose. If you're going to like University of Lagos, for instance, which was established by an act of parliament. If you go there, you see the purpose for which University of Lagos was created. If you go to UBA PLC or Limited, First Bank Limited, they can't go into construction of bridges, even though they have billions. They can't start constructing bridges because the audio clause said they're dealing only in finance, not in construction. Aviation companies, things like that. So there's always a purpose for which that company is created. So that's the capacity of company as stated in the object clause. So if a company does anything outside that object, it is described as beyond the powers of the company or ultraviolence the company, and also not being. So if where you are working as student, if you are working, I mean as businessmen and women, if you are working or if you are going to have a contract with a company, make sure that you do your background check to know whether that company have a capacity to enter into that contract with you. If they don't, then you are wasting your time. Very important. If you are going into a contract relationship with a company, and so you must check the background of that company to know whether they have capacity or the authority to do that. If you don't check all of those ones, it means that you are the one that's wasting your time. So note that as businessmen and women. Now you will see that in continental chemist and Ifekando, a chemist, was just a chemist. Now they wanted to train Ifekando to go and study abroad and become a medical doctor, so that when he comes back, the people that will come to them, Ifekando will be a medical consultant, medical doctor that will use as consultant, and then they'll also be selling drugs at the same time to their patients. So they trained Ifekando. After that, when he come back to Nigeria, he went and resigned and went and started his medical business. And when they sue him, when they came and sue him, he played that the company did not have the powers to train a medical doctor or to deal with service of a medical doctor. And true, when they went into the object clause of the company, it was clear that they don't have the object clause, nothing covering them dealing with a medical doctor. So all the money that they spend on the fake handbook got lost. Right. So if I want that is presiding in this case, what will you do? Someone that you are trained, he came back and resigned that you don't have the powers to train me as a doctor, as a medical doctor. That is beyond your powers. Ultravirus. You did that outside your powers. What can you do if you are the one involved? Ada Vivian, you want to say something?
I think he will just give up.
Okay. Even though you don't have the power, seek compensation for what you lost in that regard. Or outside that, you don't have any protection. So these are things that you need to know with respect to elements of contracts. And because of time, that brings to an end our class. That brings to an end our lectures. Yeah. So any question?
Yes, sir.
Today we have discussed all the elements. So
Hello,
in the
sir.
next class
Prof,
we'll
sir.
start with another. We discuss all the 5 elements. So our next class should be elements in terms of yes, Lekon.
Yes, sir. Thank you, sir, for the lecture today, sir. Sir, please, I want to ask about this contrast that has to do with the illiterates. And I'm just looking at the aspect that what seems to be a common terms to a professional can be an ambiguity to a layman. So I'm looking at a situation whereby some ambiguities are in a particular contract. How can we back this up with the issue of illiteracy contract? Does that contract that has to do with illiterates back up people that are involved in such contracts, sir?
I don't understand. So I didn't get your question very well. Sorry.
Yes, sir. I said in some cases when some uh, maybe law terms are used in a particular contract, and despite the fact that someone is educated but not in law discipline, is involved in such contracts, does the provision for illiterates, the contract that has to do with illiterates, work for such persons so that it will also be
Law,
explained to
law is not a,
illiterate?
law is not a language. Law is a profession now. You can only
Okay.
express law in English language. Law is not a language. You can ask any person. Law is a profession, not a language. So even medical doctors, they do in the writing in English language. Your engineers, nurses. So law is not a language. Law is not a language. Law is a profession. So and the language of law is English language. So that's why if you are a lawyer writing agreements, they will write English language. The lawyer will convert that into English language and then sign because it's traits. Even if the judge will interpret English language for you now in the language that law is not a language, it's a profession. Yes, any other question?
My lord, I have a question.
Yes, light.
Yeah, I wanted to ask. So, in the case of, for example, an hire purchase agreement given to a driver, so the regular driver will know the downfall drivers is an illiterate. Well, now you get somebody to interpret the content of the agreement to him. He's an
Yes.
illiterate, yes, but the content of the agreement has been explained to him, and he signed it. He signed the agreement in English. Do you still take him as an
Yes.
illiterate?
No, yeah, it's the person that signed. The person that is the person. Yes, both of them. The person will sign, but that cover in legal. If it's in Lagos State, you must comply with the requirement of Section 1 of the Trade Act. Otherwise, it's not binding on that downfall driver.
I'm not sure I got that very well.
I say if once it's established that that Danfo driver cannot read and write in English language, then you must comply with Section 1 or illiterate protection law of Lagos State. Otherwise, that contract is not binding on the illiterate Danfo driver. That's the law.
Okay, what of it is not in Lagos State, for example, in Abuja?
How those laws are applicable throughout the federation? They have each of them in different this. The FCT also have their own.
Uh, Thank you.
The class ended. No?
We know reach to end. The end.
Please, has the class ended?